Yay.
I am Martha Minow still, and as Dean at Harvard Law School, it gives me tremendous pleasure and a little trepidation to introduce Richard Susskind, who has for some time now been explaining to lawyers around the world that we have to understand the world is changing dramatically, and its significance for law and justice I think is now becoming clear, but Richard is someone who understood this long before anyone else. I'm going to just quote for you some of the words that have been used in describing his work. Provocative, forward-looking, eye-opening, trenchant, and he and his son Daniel have written a book not long ago that brings to bear the developments in the digital world on all of the professions. Richard Susskind is a visionary in law and an expert in computers. He brings an understanding of how online tools can transform law, but here's what's very fascinating to me, how it could improve it. That's the title today, Upgrading. There's so many things I can say about him. You should know about his role in the UK Civil Justice Council Advisory Project, developing online dispute resolution, his professorships at Oxford, 2 other universities. I could go on, but then I'd be taking money from him and time. He has remarkable offspring. I've already referred to one. We're also indebted to son Jamie, who is a scholar and technological change and political theory, and collaborating here with the Berkman Klein Center. We're grateful to Jamie for helping to give your dad as an incentive for coming here. And Richard, thank you so much for being here.
Thank you very much. Good afternoon, ladies and gentlemen. It's a great pleasure to be here. You may not recognize this man. His name's J.B.S. Haldane, an evolutionary biologist. And I came across his work some years ago, and he'd written an article, I think it was entitled The Truth About Death, and it was published in the Journal of Genetics in the 60s. And what he said of scientific theories, I think, applies quite well to the work I and others have been doing in thinking about the future of legal services. So as the Dean said, I have been going on about this for some time, my fundamental premise that technology is relevant for and will bring about fundamental change and improvement to the legal system. But the message was not always well received. And what Haldane said is in science, you find that theories go through 4 stages of acceptance. And I looked at this and I thought, actually, that maps rather well onto my own work. And so the first stage of acceptance is where people say when they hear something new, and this corresponded to when I finished my doctorate in Oxford, which was in AI and law. I finished in '86, and people, by and large, were saying this is worthless nonsense. I was talking about how lawyers might be replaced by machines in due course. 10 years later, the second stage of J.B.S. Haldane, I wrote a book called The Future of Law, and the general feeling was this is an interesting, but it's a perverse point of view. The third phase, 2006, just before I published my book, The End of Lawyers, people were saying this is true, but it's quite unimportant. And now I think last year, pretty widely thought that we're in the 4th stage. I've always said so. And I think it is true across the world, both deans of law schools, senior partners in law firms, general counsel in major corporations are now recognizing that the legal world is set for a period of considerable transformation. And I want to give you a flavor of that transformation today by looking at 7 different subjects. The future, not so much what the future holds, but how to think about the future. Secondly, the pressures, I argue, that we're seeing on law firms in particular in this turbulent legal world. Thirdly, focus in on what may be of interest to some of you, how this affects the very largest of law firms under the heading of big law. But I then want to step back and talk about something which is more important to me, which is about access to justice, not for major businesses, but for individuals. And I think we have a major problem around the world of inaccess to justice. That'll lead me to talk about some work that was mentioned again by the Dean in the opening remarks that I've been doing in the field of online courts. But ultimately, I want to return to technology and speak about artificial intelligence, which has been receiving a great deal of attention in the legal world over the last few months. And finally, say, well, what does this mean for legal education? In a sense, this talk is quite superficial. I'm skirting across all these topics, but in my books and writings, all of these are dealt with at some greater depth. But I wanted to give you a flavor of my line of thinking. So let's think about the future and my favorite story in life, about Black & Decker, one of the world's leading manufacturers of power tools. And apparently when they recruit new executives, they take them off on a course, they sit them down in a room, and they put up a slide much like the slide before you. And they say to the assembled new executives, this is what we sell, isn't it? And the new executives look rather surprised by this. They say, of course that's what we sell. We're Black & Decker. We're the world's leading manufacturers of power tools. The trainers, with some satisfaction, say, that's not actually what we sell, because that's not really what our customers want. This is what our customers want. And it's your job as new executives to find ever more creative, imaginative, competitive ways of giving our customers what they want. And there's a wonderful lesson here, I think, for everyone involved in the legal world, whether you're a practitioner, a judge, a student, or a professor. We tend in the legal world, when thinking about the future, to be of power drill mentality. We tend to think, what do we do today and how can we make it perhaps a little bit cheaper, quicker, better? Not often enough do we take the step back and ask the fundamental question, what's the hole in the wall in the world that we occupy? Why is it, for example, if you're a law firm, that our clients pay handsomely for our services? Now, I've been asking this question for 25 years. It's just to give people a perspective on thinking about the future. Because the future, ladies and gentlemen, when it comes to technology applied to the law, is not simply a systematized, mechanized, optimized, streamlined version of what we have today. The technologies we're seeing emerging are going to change the way that major clients solve their legal problems, that citizens gain access to justice, indeed the way that we teach law and lawyers. And one has to think, I think, in a more broad-minded way, in a more open way, because of several pressures we're seeing undoubtedly on law firms. I call these the more for less challenge, new competition and technology. More for less challenge summarized by general counsel, the main lawyers in major organizations, who often say to me three things. They say, firstly, we're under pressure to reduce our internal headcount, the number of lawyers we have. Secondly, we're under pressure to spend less on external law firms. And yet, thirdly, we have got more legal and compliance work to do than ever before. This is the reality for many major clients. More legal work, less resource. And I call this the more for less challenge. And it will define, it will underpin the next decade of legal practice. Now, my practical solution to this, which I put forward in 2008, a little earlier, but I think is largely accepted now, is that the challenge of taking the cost out of legal service is to look at legal work that is routine, repetitive, administrative, process-based, and find different ways of undertaking that work. But this requires you, and it's a rather unfortunate word, but it requires you to decompose, to break down, to disaggregate, to unbundle complex deals and disputes, and find out the tasks that are involved, and then ask of each task, what's the most important, or rather most efficient way of doing that work? So let me take, for example, dispute resolution. Historically, when I was in practice, what happened was a client had a dispute, and they thought, do we do it ourselves? Do we hand it to a law firm? And now we see there's a different way of looking at it. You can see that there's actually, and I'm not saying this is definitive, it's just an example of how I do it. You can divide dispute resolution into the 9 tasks you see before you, and then ask of each task, who's the best place to undertake that work? Now, I did some research in about 2004, 2005, asking the finest law firms around the world, which of these 9 tasks in dispute resolution are you, as a law firm, uniquely qualified to undertake? And the most amazing response came, and it was in England, 2, strategy and tactics. In the US, the great firms added a 3rd, which was advocacy. Because there was recognition then, even then, that a lot of the other work that goes on in litigation, reviewing documents, undertaking research, the project management, for example, could be undertaken by a new wave of suppliers at a lower cost and to a higher quality. And that's why I wrote a book, The End of Lawyers? Because it occurred to me, if we apply a kind of manufacturing production mentality to the delivery of legal services, if we decompose work, and we see that much of the work can actually be unpacked and delivered differently by non-legal providers, then that's surely of profound impact or implication for the legal world. And for those who are involved with transactions, it's exactly the same. You can divide a deal into these 9 different tasks. I say, again, not definitive, but gives you a flavor of my line of thinking. And the final step in this argument is that there are at least now 16 different ways of sourcing legal services. No longer is it insourcing by the client or handing it out to the law firm. There's all these new options, outsourcing, offshoring, subcontracting, and the rest of it. The details don't matter. It's a line of thinking here That no longer is legal work some monolithic, indivisible lump of stuff that can only be done by one organization. We're seeing a far more flexible way of delivering legal service. And so that's the first pressure on law firms, the more for less pressure. The second is new competition. Now, some people want to talk in this context of the Legal Services Act 2007 in England, the Liberalisation Act, which allows non-lawyers to deliver legal services. It allows private equity and venture capital to put into legal businesses. It allows the establishment of a new kind of legal business called the alternative business structure. Now, that's important, and it's changing particularly consumer law in our country. But the bigger point I'm making here to major law firms is this, that the competition that kills you doesn't look like you. When you're in a time of great change, at an inflection point, as I believe we are, what we're seeing is new competitors in the marketplace who are delivering legal services in different ways. And so the real competition for the law firms is not the ones that they look at all the time, it's the accountancy firms. And David Wilkins, who's here today, has written an article precisely on this, the Big Four returning to the legal world. PwC already has 3,500 lawyers in 90 countries. They're just warming up. Deloitte spent more last year on training than the fee income of the largest law firm in the world, just to give you an idea of scale. And then there's the publishers, people like Thomson Reuters. If they were a law firm in terms of the number of qualified lawyers they have, they'd be the 10th largest firm in the world. They've also got 2,000 software engineers. They own the leading package that delivers document automation. They own a system service, really, that delivers know-how and research. They have a legal process outsourcing company in India. They're very credible competitors to conventional law firms. In England, there's the alternative business structures. And then there's the legal tech startups. Just a few years ago, there was a couple of dozen of these. Now there are over 1,000. Each one trying to do to a corner of law what Amazon did to book selling. And also a competitor, of course, in-house legal departments, where the legal work is no longer done by law firms, it's done in-house. And you'll see we're going through, and I think it's slightly cyclical, but we're going through a period where in-house legal departments, by and large, are getting larger. And so if you imagine the average law firm as the character in the middle there, swimming along in confidence that they have the competition, the inferior competition, well within its sights, I'm suggesting they perhaps have no sense at all of what's coming up from behind. So think about this, the two stages, huge commercial pressure, that's to say the more for less challenge on the one hand, and on the other hand, new players in the marketplace. This is building to be a perfect storm. But technology, for me, the third element, will have the most profound implications. I take you back to 1996 when I wrote a book called The Future of Law. And in that book, and this sounds completely absurd now, one of my themes was about electronic communications. I was giving lots of talks at the time saying the dominant way that lawyers and clients will come to communicate in the future, I was claiming, was email. Now this, of course, sounds, as I say, faintly absurd now. But at the time when I was making this suggestion, the Law Society of England and Wales said I shouldn't be allowed to speak in public, and that I was bringing the legal profession into disrepute by suggesting email would be the dominant way of communication between lawyers and clients. I say this today not to, well, maybe just a little bit to vindicate, but more to say to you that I will be pointing to a number of technologies over the next 10 or 15 minutes, and as law students, you may think, well, I can see what he's saying, but how does it really apply to law? I think they're all way more predictable than email was in '96. Now, the way that Daniel, my son and co-author, he's an economist at Oxford, the way we look at technology and the way we explain it is under 4 headings. We talk about the exponential growth in the underpinning technologies. We talk about our machines, and this is in a sense our signature phrase, becoming increasingly capable. The systems around the world are taking on more and more tasks. No one in Silicon Valley is dusting their hands off and saying, job done, we'll call it a day now. Our systems are doing more and more. They're also becoming increasingly pervasive, not just because we all carry handhelds, but also through the Internet of Things that chips are embodied in and being embedded in millions and soon billions of everyday objects. And finally, as human beings, we're becoming increasingly connected. I want to talk a little bit more about the first, second, and fourth of these, just to give you a flavor of the exciting times in which you have been born. Now, to understand the exponential growth in technology, you need to think not of a law of the land, but of Moore's law. Gordon Moore, the man who 52 years ago said something apparently innocuous. He said that, and this is a huge paraphrase, but said every couple of years, the processing power of computers would double. Now, those of you who enjoy math will remember that if you actually keep on doubling anything, although at the beginning there seems to be some kind of shallow and not particularly great effect, In due course, this gives rise to an explosive growth in whatever phenomenon we're concerned with. And almost under any heading when you look at technology, we're seeing exponential growth. Let me give you a flavor of exponential growth in action. Take an A4 sheet of paper, 0.06 millimeters in thickness. Fold it over once in itself, again in itself, 4 times in itself. It then becomes the thickness of a credit card. Nothing remarkable there. After 11 further folds, it becomes the height of a Coke can. Not yet amazing. After 21 folds, it's the height of Big Ben. After 43 folds, it's the distance from here to the moon. And after 100 folds, it's 8 billion light years in thickness. This is what happens when you keep doubling anything. And it sounds science fictional. And I want to make the point to you as strongly as I can that what's happening in processing power signals that we are living in a time of greater and more rapid technological progress than the world has ever seen. It's happening on your watch. You're growing up in this generation of unbelievable technological change. My message today is that as you move from law school into whether it be legal practice or the academy, but actually one should be harnessing this technology in improving the way we deliver legal services. Let me show you the exponential argument in a different way, the fable of the tramp and the princess. The tramp saves the princess's life, and the king says to the tramp, I will give you by way of reward anything in the kingdom. The tramp says, I want something rather simple. I'd like a chessboard with 64 squares as normal, and in the first square, I'd like you to put 1 grain of rice, and the second double it to 2, and the third to, again to 4, and the fourth to 8, and so forth. Just keep on doubling as you go around the chessboard. And all I would like, Your Majesty, is all the rice that would then appear after 64 doublings. The king thinks he's got off lightly here, and he says, I grant you that wish, but it transpires it's not his to grant, because that would require more rice than there is on planet Earth. This is the doubling effect. Now, Moore's Law, we're now, as people say, we're the early part of the second half of the chessboard. We've about 33 or 34 doublings of Moore's Law, and the impact so far has been remarkable. To give you a flavor, by 2020, the average desktop machine will be able to process at the speed of 10 to the 16th or 10 to the 17th calculations per second. And neuroscientists will tell you that's about the same processing power as the human brain. That's amazing. Not as amazing as this. By 2050, if Moore's Law continues, and most material scientists and computer scientists will tell you that it will, by 2050, the average desktop machine will have more processing power than all of humanity put together. And think about 2050, you guys will be not much older than I am today at that stage. This is happening during your time, that our machines are developing at a remarkable and a disconcerting rate. Am I exaggerating? Am I one of these guys who goes around exaggerating for a living, as it were? But well, I really am. I'd look at someone wildly more eminent than I said. Michael Spence, Nobel Prize winner in economics, in his lecture in 2001, pointed out he noted a roughly 10 billion times reduction in the cost of processing power in the first 50 years of the computer age. Doubling in processing power, halving in costs, comes to the same thing. But remember, that's 2001. In 2003, it would be 20 billion. In 2005, 40 billion, and so forth. So there's something very remarkable going on. And it's not just in processing power, it's in data too. Look what Eric Schmidt, Google's chairman, said. Every 2 days now, we create as much information as we did from the dawn of civilization up until 2003. Every 2 days now. Now, Daniel and I have projected this forward, and by 2021, that'll be every hour. Every hour, we'll be creating that amount of information. If you want a little more prosaic example, the little memory cards in our cameras. In 2005, a good card was 128 megabytes. Fast forward 9 or 10 years, 2014, 128 gigabytes. More than a 1,000-fold increase in less than 10 years. That's more than a doubling every year. You can hold all the world's recorded music in a little box you can fit in your hand. So whether it be processing power, hard disk capacity, bandwidth, whether it be random access memory, we are seeing an exponential increase in the underpinning technologies. And this is fueling what I referred to earlier, our machines becoming increasingly capable. They're doing more and more. And we look at this under 4 headings, and I want to look at 3 of them with you today. Big data, problem solving, and effective computing. Not so much in robotics today. That's for another time. But let me look at these 3 elements of our machines becoming more capable. The first depends on this idea that we can derive value from the huge amounts of data that we are creating as a byproduct as users of the internet and of technology. Some people call us the data exhaust, all the data that comes out metaphorically behind us as users, all this stuff that's created, which in a sense captures so much human experience. And the field of big data or predictive analytics or machine learning, they're all roughly equivalent, is suggesting that this data that we're generating of itself can yield insights, patterns, and correlations. And this is fascinating. Let me give you a simple example of Lex Machina, a system now recently bought by LexisNexis, who's developed in Stanford. This is a system that predicts the outcome of patent disputes more accurately than any human patent lawyer. Now, how does it do it? It knows nothing about patent law. That's the first thing to know. But it's got about 100,000 past cases, information such as who the judge was, what the courtroom was, who the lawyer was, the law firm, the litigant, the value of the claim, the nature of the claim, a whole bundle of variables. It transpires that you can make a more accurate statistical prediction of the outcome of the courts based on that kind of data than based on legal reasoning, legal problem solving, the standard legal method. Now, this is a big challenge to all of us. My background is in jurisprudence and legal philosophy, so I find this an amazing concept, but practitioners find it challenging too. You think, well, actually, the system doesn't know anything about law, so what's it doing? And then you have to think of the client. What's the question every client asks when there's a dispute coming over the horizon? What's our chances of winning? You know Maslow, the great psychologist, organizational psychologist, who said, if you're a hammer, everything looks like a nail. And if you're a lawyer, everything that comes your way seems to look like a legal problem. So we think the question, what's our chances of winning, is a legal question. But actually, for the commercial client, it's not. If it turns out there's a system that can offer a more accurate prediction of the outcome of the courts than the standard legal method, in commercial terms, in market terms, there'll be a default to that option. And this goes back to the hole in the wall and the power drill. The power drill is our way of delivering an answer to the question, what's our chances of succeeding, whereas the hole in the wall is what the client actually wants. Moving away from big data to question and answer systems to problem solving by computers. Watson by IBM, you'll all know about this. 2011, in a live episode of your TV quiz show, Jeopardy, a machine called Watson beat the two best ever human Jeopardy champions. And in effect, that's answering questions on anything in the world more accurately and more rapidly than the best human beings. And Watson now, of course, are investing heavily in other areas, most notably in health and the level of diagnostic performance, the quality of treatment plan, the way in which the system can manage the huge amounts of medical research that's generated on an annual basis. It's very clear in the 20s this won't just be outstripping individual doctors, it'll be outperforming teams of doctors. And these systems, a very specific form of AI system, the question and answer system, essentially a system that can ask questions, answer questions that are put to them, remarkably powerful. A third area of systems becoming increasingly capable is a branch of computing I suspect few of you will know about called affective computing. These are machines that can both detect and express human emotions. A machine that can look at your face and tell whether or not you're happy, surprised, angry, or disgusted. There's a system now more accurately than any human being can look at a human smile and tell whether or not it's fake or genuine. There's a system more accurately than any human being can now listen to two female voices and tell whether or not they belong to a mother or a daughter. In the early 20s, your handheld machine will know what kind of mood you're in and will respond accordingly. Your jacket will give you a little hug when a friendly message comes in. We'll start interacting with our machines, our little robots, as if they're pets and friends. And so we're seeing a new generation of machines, better than human beings, at understanding your mood, at reading the signals. Certainly better than lawyers with clients. And secondly, machines that will be able to respond accordingly will know how best to react to the mood of the user. And these are huge leaps forward in the field of technology. I also mentioned the machines are becoming increasingly connected. That was my fourth category. And I'm not just meaning here, although this is very important, the remarkable desktop-to-desktop high-definition video conferencing that will radically change almost all the work of lawyers who feel the need physically to get together with their clients, because these new systems are remarkable. But I'm talking about other systems, for example, patients like me in medicine, where you've got about 400,000 patients. Patients usually who are suffering from chronic illnesses who say they derive greater comfort. Indeed, they get better insight and guidance, not from the medical profession, but from fellow sufferers. Now, you will very soon have law clients like me. That website is still available. Law clients like me, it'll be a first port of call to so many people when they need legal help, legal guidance, and legal insight. This is the way, in many ways, of the web, that people come online and help one another. They make available the insight, the guidance, the experience that's helped them. So there you go, exponential growth in the underpinning technologies, our machines becoming increasingly capable. I didn't expand on this, but they're, as I mentioned, becoming increasingly pervasive too, and we as human beings in new technologically enabled ways becoming increasingly connected. Here's the stunner. There's no finishing line in this. This is the thing I find hardest to grasp. There's every chance that by 2025, the technologies that will have changed all our lives, they're technologies that haven't yet been invented. This is the speed of change we're seeing. Now, what does this mean for big law? And many of you will want to go into big law. What do I mean? It's not a phrase I particularly enjoy, but I think we know it's usually people refer to the 100 biggest firms in the world that together generate fee income of over $100 billion. Big business. Very often, and I, for a living, speak to major law firms, partners, conferences, in the very strong sense, certainly at the beginning of the lecture, but I'm sure not at the end, that they would say, this doesn't apply to us. I understand, Richard, the world's in for a shake-up, but we're different as big-hitting lawyers. For one reason or another, our creativity, our insight, our interpersonal skills will always be needed in the old way. They want to argue they're an exception. Well, we're seeing huge changes in the way that medicine's practiced, the way that education is proceeding, the way that architects, tax advisors, accountants, even the clergy are changing. Somehow it doesn't apply to big law firms. And the argument they run goes something like this. They say, in bet the ranch deals and disputes, the ones that really count for our biggest clients, this legal work is price insensitive. The client doesn't care how much they pay us because there's so much at stake. We're safe. No one ever got fired for buying IBM. No one ever got fired for hiring one of these big law firms rather than a cheaper version. And $1 million here or there makes no odds in the scheme of the kind of deals and disputes we're talking about. And that sounds superficially plausible. But I say to you, just not so fast. There's a little bit of sophistry involved there. First of all, the research I've done suggests that price-insensitive work is declining. The amount of work that clients are prepared to say doesn't really matter how much it costs. That's a diminishing category. Then remember decomposition. Just a few minutes ago, you can break down legal work. So RBS, the biggest legal client in the United Kingdom, in a big deal now, will give the difficult legal stuff to the elite law firms and gives the more routine stuff to regional firms and to other providers. So while it might be you have always got a seat at the table, you might have far less to do. There's also major new players. The big four firms are more plausible at board level than even the major law firms. And if they are coming on board and saying they can offer many of the services, the project management, the document management, and so forth, and will subcontract the difficult legal stuff to the technical lawyers, the lawyers, again, are still in the frame, but not generating the income they used to. And then there's the possibility of an elite firm breaking rank. You may think, well, that's not going to happen. One of my clients is Alan Overy, and together with another one of my clients, Deloitte, although I had nothing to do with this project, they have come up within the last few months with an entirely different solution to the management of the major changes we're seeing in regulation of derivatives globally. Basically, a huge burden on investment banks as they're trading so regularly in derivatives, ensuring compliance. And long story short, they developed a system that technically is not that sophisticated, but its impact is profound. It means that human beings don't need to handcraft the compliance work to ensure that these banks are complying with appropriate regulations. This is a system that's generating remarkable fee income, unprecedented in the world of legal technology. It's a system they very definitely had first mover advantage. There was a whole bundle of other law firms thinking about doing the same thing. The minute that system was launched, the others were blown out of the water. But almost most importantly, legions of major law firms around the world that thought they had a cash cow coming along here. The manual, traditional, bespoke handling of the compliance challenge of a new set of derivatives regulations, it transpires that someone else has actually just changed the market. And this will happen more and more. And this, in the language, is disruptive innovation. And again, that's something that David has been leading the charge on in Harvard. There's another whole set of arguments that I only want to point you to today. This is what Dan and I came up with in our book, The Future of the Professions, is that we're seeing actually 6 alternative models for the delivery of legal service, professional service generally emerging. I'm not going to go into them in detail, but the big point here is that we have relied for so many years on this concept of one-to-one consultative advisory service, often on an hourly billing basis. And in our research across the profession, we see the emergence of 6 credible and in the end probably lower cost options enabled, fueled through technology. Let's talk a little bit about access to justice and start with Kafka, because he, it seems to me, sets the debate so very importantly. So we're not talking about big companies now. We're talking about ordinary people, citizens, who it seems to me are essentially excluded from most of the legal process. Before the law, he says, stands a gatekeeper. A man from the country comes to this gatekeeper and requests admittance into the law. But the gatekeeper says that he cannot grant him admittance right now. The man from the country had not expected such difficulties. After all, he thinks, the law should be accessible to everyone at all times. The law should be accessible to everyone at all times. And it manifestly is not today in most so-called advanced jurisdictions. Just a few of the problems. Using lawyers, using the court system is too costly, it's too slow. To the non-lawyers, unintelligible. It's largely fairly combative. Even the way we do deals in common law systems, we act as if they're disputes. And it's out of step with so much else we see in the internet society. I want to redefine access to justice. I think when you speak to many judges, and certainly in England, Lord Woolf, who became our Lord Chief Justice, in the mid-90s, he wrote 2 very influential reports called Access to Justice. And in terms of improving access to justice, he meant really improving access to the court system, access to judicial dispute resolution. But I think a great justice system will do far more than just offer effective dispute resolution. Surely it should also offer and enable and encourage dispute avoidance. I sometimes call this putting a fence at the top of the cliff rather than an ambulance at the bottom. And so many law reform initiatives focus on getting the ambulance to the scene that bit quicker, or equipping that ambulance that bit better. I've never met a chief executive nor an ordinary citizen who prefer a really large dispute well resolved to lawyers to not having a dispute at all. That's not the way the non-lawyer mind works. Dispute avoidance surely has to be something that our legal system supports. And also, if there is a dispute and we can't avoid it in the first place, surely the system should be set up to discourage escalation of disputes, to discourage disputes from, as they so often do, flourishing in the hands of the legal world, judges and lawyers alike. We need methods for dispute containment. And we also, it seems to me, need to stop thinking of the law in terms that are purely obligatory. So those of you who studied Herbert Hart's work, The Concept of Law, one of his fundamental distinctions was between duty-imposing and power-conferring laws. And he says the public perception generally of the law is it's about imposing duties, prohibiting, prescribing. But he says one of the great things of the law is it confers powers on us. It allows us to get married. It allows us to make contracts. It allows us to make a will and so forth. And legal health promotion is surely about not just helping people avoid or resolve or contain their problems, but making sure that people can take advantage of the facilities of law that empower. And that seems to me to be a broader conception of access to justice that many people have in mind. Think of what happens when you go to the lawyer or need legal help. I have this idea of the legal service chain. And there's 3 stages. There's the process by which you recognize you need and would benefit from legal help. There's a process by which you select the most appropriate form of help. And then there's a process in which the service is delivered. The problem with the recognition process just now is for many non-lawyers, you don't actually know very often you've got a legal problem until it's too late. We all know the blatant trigger. Some formal legal document comes in, or you decide to get divorced, or whatever. It's obvious you need legal input. But very often, people go to the lawyers, and the lawyer will, with a sharp intake of breath, say something like, I wish you'd come to me 3 weeks earlier. And it's fundamentally unhelpful for the client, that. The paradox of traditional reactive legal service is it seems that you need to be a lawyer to know when best to consult a lawyer. And that's problematic. And it's a huge problem. And then there's problems in selecting. How do you find a lawyer if you've never used a lawyer before? How do you know if it's a lawyer you need or some of the other advisors we've been talking about? And if you think, well, maybe it's help online, how do we find that help and how do we know if it's reliable? And the delivery of service, again, how do lawyers do it? How do non-lawyers do it? And might systems deliver the service? So, and this is a major thesis in its own right, but there's a whole set of tools and technologies we should be thinking about to improve the recognition, the selection, and the delivery of legal service. And so, very briefly, in terms of recognition, the idea of online triage, you should be able to go online with a grievance, and the system should be able to at least point you in the right direction, tell you what kind of problem you've got, what kind of means of resolving them there might be, what options available to you, and so forth. Now, we can also embed, and this is a fundamental point in the future, we can embed law in our working practices, in our daily lives in a way that will mean we don't need to consult lawyers. Very quick example. When you use your handhelds and you play the card game that is called solitaire on your handheld, when I was young, and anyone of my age, we used to call it patience, and we played it with playing cards. We played it with atoms. The question I often ask when you play it with playing cards, what happens when you try to put a red 5 under a red 6? It's called cheating, but what happens? You can do it. You can do it. What happens when you try and do that with the online version? You can't do it. Why can't you do it? Because the rules are embedded in the system. You don't need to know the law and then make a decision, am I going to comply or cheat? The rules are embedded in the system. And so much of the law in the future will be embedded, particularly in the world of the Internet of Things, self-driving cars. It won't be that anyone will be thinking, should we drive more than 50 miles an hour? It'll be embedded in the system. So much of our law in the future will be embedded. So you don't need to recognize. The burden of knowing when you need legal input will be removed from us. Then alerting. Very easy in different trades and professions and walks of life to sign up to alerts that will tell you when there's been changes in relevant law or introduction of new laws. And then also online community, a bit like Patients Like Me, communities of legal experience, where people, when they have issues, will be in dialogue, and it'll be other non-lawyers will say, I'd watch out for that, because you're in the early stages of something that really hit us badly. In terms of selection, online auctions, online reputation systems like TripAdvisor, online price and comparison systems, and again, online community to help you point towards the relevant resource. The service itself, some of it will be online advice, online dispute resolution, more of which in a second, automated production of documents. So in all areas, if one thinks deeply about the access to justice problem, even in its widest sense, there's great scope for technology to help. And if you're skeptical, there's lots of mainstream examples, but a couple of outliers that I like. A 19-year-old in England developed what we called a robot lawyer, but essentially a system if you've got a parking fine. You can go online, and he would guide you through the process of appeal. And so far, he's managed to overturn 160,000 parking tickets. And there's a little system that manages through quite a complicated, self-contained area of law. Or have a look, and it's fantastic what they're doing in Uganda, the Barefoot Law Initiative. And it puts so many advanced jurisdictions to shame, the way they're using mobile phones. Their big problem is they don't have power to charge up the mobile phones. But you've got a group of students who are now setting up this business who are actually greatly increasing access to justice, particularly to people who are in one way or another oppressed. It's absolutely inspiring. And similarly, as in China, if you look at Fabio, I was similarly inspired. Here's 12 million people, either by telephone or online service, benefiting from the collective guidance of 45,000 lawyers for an insurance policy of about $2 a month rather. These are different ways of delivering legal services, but we're so, I'm afraid, William Blake talked about mind-forged manacles. We have a way of thinking about the law which involves lawyers and courts and traditional legal concepts, which is at variance with, and it seems to me, is giving rise to a fundamental inaccessibility that is a grave social ill. Let's talk about online courts. So the fundamental question I ask here is court a service or a place? Do we really need physically to congregate together to sort out our differences? Well, this is a question I was asked as the chair of a group, an advisory group for our English Civil Justice Council, and we were asked to look at online dispute resolution. The problem we were given was echoed earlier, our courts are too costly, too slow, too forbidding, they're unintelligible, they're too combative. In many ways, they're a disproportionate solution to so many legal difficulties. We have a vast issue of unmet legal need, and the court system itself, one only needs to wander its corridors to see it doesn't sit necessarily very comfortably with the internet society. The Master of the Rolls put it better. Master of the Rolls is the senior civil judge in England and Wales. He said, any system that's got a 2,000-page user guide has got a problem. And that's the English civil court system. So our work was to have a look at this field of online dispute resolution for civil disputes under 25,000, to look at future developments, put together a team of people, a few of them had doctorates in the area, practicing lawyers, academics, officials, with a great mix of people. And we published a report in 2015, and there's a website there as well, and we did interviews with 6 leading authorities in online dispute resolution. We were attracted by this. Imagine a court system where dispute resolution was as easy as using Amazon. Imagine a system that was genuinely affordable. And I was struck in a conference when I heard a charitable representative say that the homeless now have handhelds, that so many people now, even people of very little personal financial worth, actually have access to these systems. We get submissions on disabled. How many people, and it's many, many millions in our country, cannot attend court or can only do so with great difficulty because of their physical disabilities. Imagine a system that was more natural for the internet generation. Imagine a system where you took all sorts of ill-suited cases out from the courts and saved money there. And if we could meet this growing problem of unmet legal need, increase access to justice, or as the Dutch put it, because they're doing parallel work, imagine a system that's fast, fair, and efficient, and we add to that proportionate. It's not a new field, online dispute resolution. There's been books written over the past 15 years. We wanted to embrace the wider conception of access to justice that I've mentioned. So just now, if you think of the 3 levels that I was talking about, dispute avoidance, containment, and resolution, the emphasis of the state tends to invest in access to justice in the sense of court system, dispute resolution at the bottom. We made a different recommendation. We said set up an online court, a 3-tier service. Have judges still, very clear, it's still judges, not machines making decisions. It's judges coming to decisions, but actually doing so on the papers alone, maybe with some video conferencing or some telephone conferencing, but fundamentally on the papers alone. In the many cases that judges tell me, you don't need really to have people physically congregating. But before you get there, why don't we have case officers? We call them facilitators, people who could help the parties in the spirit of ADR and maybe recognize that some cases shouldn't actually go to the court system at all. And before you get there, why not have online systems that can do some online diagnostics and can guide you through the issues so you understand your options and entitlements? So it's turning the concept in its head. It's introducing a system, move away from the adversarial online judge. We'll have that, but almost its last resort. The level above that is dispute containment through this online facilitation. It's more inquisitorial and investigatory. And before you get to that, a top tier, avoiding disputes through online help. And it's more informational. We said it's a bit like the moment the dentists face when we realized if you put fluoride in the water, you can greatly reduce the amount of people who need to have the service of the professional. That was our model. Lord Dyson, again, the Master of the Rolls, said publication of this report is an exciting milestone in the history of our civil justice system. It was a great moment for our team. And he pointed, as we did too, to the benefits. If you introduce this system, certainly for low-value disputes, fewer cases would reach judges. Those that do would cost less because you reduce the estate. The top 2 tiers would increase access to justice. And we accepted this not for all cases, but just at least for some cases. This idea of judges without courtrooms, justice without lawyers, anathema to many legal theorists and to many practicing lawyers too. We pointed to eBay. 60 million disputes resolved every year on eBay, not by lawyers, but by online dispute resolution. To the Financial Ombudsman Service in England, 500,000 disputes resolved every year, only 20 of them in person. How do people respond? The media, very, very positive indeed. The Lord Chief Justice, even more positive. The then Lord Chancellor, equally supportive. This was all amazing, because I've, for 35 years, been banging on about this stuff. Then, above all else, I suppose, the Treasury announced that it was going to put £738 million into modernizing and digitizing our justice system. And then one of the senior Court of Appeal judges, Lord Justice Briggs, who in parallel was doing a review of the civil courts in England and Wales, came out in favor, both in his interim report and his final report, of our model, and that is what's being implemented. All of this was brought together in the recent paper called Transforming Our Justice System. I've had a change of color here because the legal profession didn't respond well, by and large. They said this was an economy class justice, there wouldn't be a fair trial, it'd be bad for the digitally deprived, we're trying to exclude lawyers, and it's all about cost savings. All of these are serious objections, but to all of them there are serious responses too. On Thursday, I'm giving a talk called The Case for Online Courts, and we've got the president of the Law Society, the chairman of the bar, the head of the tribunals, and the head of the court service all responding. But we have a movement going, and it's terribly exciting, where actually there's more and more people who think this is a sensible way of resolving disputes. My recommendation is let's not get ahead of ourselves. We should start modestly by piloting it. We've got to study the results, decent empirical research. We should build incrementally and refine as we go. Not one big bang. We've got to show some restraint. The bigger point is there's no credible alternative narrative. I'm not hearing from any lawyers, here's the alternative. All lawyers can say is we need more public funding of legal service. But even if you had public funding of legal service, the truth is the traditional system is disproportionate. Let me say something about AI and then begin to close. AI has received a lot of attention recently in the Financial Times. 4 of our biggest law firms in England have committed to AI. A little bit of time travel here. I was involved in the development of the first wave of AI. I wrote my doctorate from 83 to 86 in Oxford in AI and law, and from 86 to 88 developed the world's first commercially available AI system in law. Here was the problem we tried to resolve. Section 2 of this Act shall not apply to an action to which this section applies. Now, someone somewhere presumably thought that was okay, but this is an extract from a piece of legislation that's being inserted in our limitation law and changing basically the question being asked and answered is when can an action no longer be raised because it's time barred. And a friend of mine who had been the dean of the law school in Oxford and been one of my examiners had written the definitive book on this subject, the subject of the Latent Damage Act 1986, and we developed a system. Now this was the front screen of the system, and I want to show you at the time this was just unimaginably cool. This was state-of-the-art graphics, and it's just an embarrassment now. But basically what we did was we reduced Philip, this is the leading expert reading textbook in the field. We reduced his expertise to a system, and this was when floppy disks genuinely were floppy, 5¼ inch floppy disks, a system that would ask a series of questions, essentially a big decision tree, a huge decision tree. There were over 2 million paths through this system we developed. And it would ask a whole series of questions about a dispute, and it would tell you when you could no longer raise an action because it was time barred. Really complex area of law. Our research suggested that this would reduce the time to solve that problem from hours to minutes. And the great thing was, Philip to this day will say, in the end, the system was better than him. It outperformed him. So why didn't these systems take off? First of all, very costly to develop. Secondly, at a time that we didn't have the more for less challenge there. Clients weren't really clamoring for reductions in fees. So law firms were saying, hang on a second, if clients aren't wanting us to charge less and our competitors aren't undercutting us, why on earth would we want to invest in a system that will reduce research time from hours to minutes? The bigger point was this, and this is my own pet theory about AI and why we had what's known as the AI winter. When the web came along, suddenly we found a way of making legal content, guidance, and advice available online at very low cost. And so many of us just stopped working in legal AI and moved over to legal web. Not as sophisticated a technology, but far greater impact. And then something very strange happened in 1997. Garry Kasparov, the world chess champion, was beaten by a computer system called Deep Blue. Now, in the 80s, when I was doing research in AI and was working in the computing laboratory in Oxford, we thought that wasn't possible. And the reason we thought it wasn't possible is terribly important. We thought it wasn't possible because the way you developed systems in the 80s to perform at the level of experts, we call them expert systems, was to do what I did with Philip, to sit down with an expert, mine the jewels from their head, put it into a big decision tree, put it in a computer system. But many experts say, I can't reduce my expertise to rules. A chess player, a doctor will say, it's intuition, it's knee-jerk, it's gut reaction, it's genius. It's ineffable. We can't articulate that. It's called tacit knowledge. And that led to quite a comfortable conclusion. Systems can take you so far, but the real magic requires human beings. And that's the conclusion that people still want to draw today. What we missed out on, and what everyone today misses out on, is by the time 1997 came along, the exponential increase in the processing power of machines meant that Deep Blue could process 330 million possible moves in a second. A good chess player can juggle about 100 moves in his or her head in one moment. Kasparov was not beaten by an intelligent computer system. He was outgunned by brute processing power, huge amounts of data, and clever algorithms. And that, ladies and gentlemen, is what's going to outgun all of us. There's lots of ways of being smart that aren't smart like us, MIT's Patrick Winston says. It gives rise to what Dan and I call the AI fallacy. You shouldn't think that the only way to develop systems that are going to perform at the level of human experts in law, for example, is somehow to copy the way that lawyers work. That's what I did in the 80s, and it still works, but it was mistaken to think that's the only way you can computer systems to solve legal problems. Go back to the example of the big data instance of a system that can predict the outcome of courts. It doesn't do it like us. It does it entirely different ways. But you don't understand, Richard. My clients come to me for my judgment. How can a computer system ever replicate judgment? And we say that's the wrong question. The better question is, to what problem is judgment the solution? Why is it that people come to lawyers and ask for their judgment? And our answer to that is, very often it's because it's uncertainty. Clients come to professionals because they are in uncertain circumstances. Facts are uncertain. Professional knowledge is uncertain. In your experience, in your judgment, what should we do? So the better question, though, is not, can a computer system replicate judgment? But can a computer system handle uncertainty? And actually, all the suggestions we're seeing from all the research and big data and so forth say that not only can they handle uncertainty better as well as human beings, they can do so better than human beings. And this is the power of the data, that insofar as clients come to us under conditions of uncertainty, we can expect machines using their own distinctive capabilities to sort out legal problems in new ways. Can machines think? It's a great question. Remember IBM's Watson. The day afterwards, John Searle, the day after IBM Watson won in the quiz show, in the Wall Street Journal, John Searle said, Watson doesn't know it won in Jeopardy. It's just perfect. Watson didn't phone up its mum to say how chuffed it was to have won. It didn't want to go down to the pub to celebrate. Watson didn't want to do anything. Be very clear, these increasingly capable machines are non-thinking. Don't fall into the AI fallacy saying lawyers are safe because machines can't think, and you need a thinking machine to sort a legal problem. These machines are outperforming us, but they're non-thinking. They're working in new ways. And that's the second wave of AI. A little bit illegal education then. And finally, the question in light of all of this is, what are we training in large numbers young lawyers to become? Traditional one-to-one bespoke face-to-face consultative advisors who specialize in individual jurisdictions and charge by the hour? Pretty much yes. Or flexible, team-based, technologically sophisticated, commercially astute, hybrid individuals able to transcend legal and professional boundaries? I won't say anything about Harvard, but by and large in most law schools, this is not on the agenda. What about the 2020s? I won't dwell on this, but these are the people who will be solving the problems to which current lawyers are the only solution. It's the most important slide of the day. These are the skills you're going to need in the 20s to sort out legal problems. The fact that you don't recognize most of these jobs is fascinating. It's not, the 20s is not the decade of unemployment. It's the decade of redeployment. There's only one decision you need to make in your career, and only one decision any business needs to make in its strategy for the 20s. Do we compete with machines or do we build the machines? Do we say, actually, despite everything that Richard says, and all the evidence to the contrary, there's still so much that we can do as human beings that machines can never do, that's how I want to carve that out as my career, my business? Or do you want to recognize, as, say, one of the big four has done by saying, by 2020, 25% of its tax specialists will be technologists? Why? Because clients are wanting technological solutions. So rather than saying we don't do that, we're tax specialists, you say, yes, we do that. We build the systems. That's the future of legal service. You're involved in building these systems. My problem is in many UK law schools, the law was taught as it was when I was there in the 70s. No regard for globalization, commoditization, technology and AI, modern business management, decomposing, alternative sourcing, all the stuff I've been talking about. Many law graduates in the UK today, I hear from law firms, are ill-prepared for everyday legal work, still less for the changes I've been talking about. So should we extend the remit of schools, colleges, and continuing education to include other disciplines? Risk management, project management, legal knowledge management, disruptive legal technologies? Should that be part of the curriculum? Is there a place for the future in busy law curricula and in law firms' training programs? Very plausibly, so many law professors say, look, there's a core subject, constitutional law, contract, tort. We cannot not teach these, and I agree with that. And so, but I do look at universities, and you're there. I look at universities in the United States and see there's a beginning of a movement where within the law schools one can learn about the future, one can pick up some of these new skills. And here's the equivalent in the United Kingdom. Nothing. We haven't got a single law school in England that's doing anything. And it's something, as you can imagine, I go on about a bit. What are the reasonable expectations of the people in this room? I say this, and I said it in my book, Tomorrow's Lawyers, which is just about to come out in the second edition, which is all about this. I'm not saying this should be compulsory, but I think every law school should offer options to have courses in this kind of subject so that you law students can study current and future trends in legal services. And secondly, there should be the opportunity, maybe delivered by the profession, to learn some 21st century legal skills, the knowledge engineering or the project management, whatever it might be. And in those law schools that have been doing this, we're already seeing, even if it's an option, they're taken up. There's also the question of how we're training young lawyers. I mean, if you look at some of the work, say, of Paul Maharg, whose work transforming legal education, simulated legal practice environments. There's entirely different ways we can actually teach law as well. We should use 21st century methods. So ladies and gentlemen, when I talk about upgrading justice, what I have in mind is this. Although we're making some progress, our legal profession, our court system, our legislature, and our law schools, I believe, are still largely 19th and 20th century institutions that, frankly, in many respects, are no longer fit for purpose in the 21st century. Just a few of the problems: too costly, too slow, unintelligible, too combative, out of step in the internet society. So the challenge, and this is the challenge of upgrading justice, is to harness the power of existing and emerging technologies in comprehensively modernizing, improving our profession, our court system, our legislature, and our law schools. In the end, it's about using technology to increase access to justice, to promote the rule of law. For people of my generation, that's our legacy. For tomorrow's lawyers, that's your future. Thank you very much.
So, Richard, that was a typically brilliant Richard Susskind tour de force, delivered in that typically amazing Scottish brogue, which makes it sound even better. But I want to ask you a question about the relationship between the first half of your talk, roughly speaking, and the second half. So the first half was all about how big users, mostly big corporate users of legal services, are going to master all of these technologies to get what they want cheaper and faster.
Yeah.
And the second part of the talk was all about how it was going to increase access to justice. You may know that 40 years ago, Mark Galano wrote this very famous article called Why the Haves Come Out Ahead. And it was all about how the haves reinforce their advantage over time by playing for the rules, working through institutions, controlling all of the underlying processes. Why isn't the story you told in the first half exactly why the second half isn't going to work, except by taking those smaller disputes and allowing people to operate in a small sphere, but not where there's a big challenge across the V between the powerful and the powerless?
I'm not sure I just see a distinction between the first and second half of my presentation. I think they're two sides of the same coin. Whether I undertake research with consumers or with Global General Counsel, they're fundamentally saying the same thing. They weren't saying this 10 or 15 years ago. They didn't have the more for less challenge. I think the system, without overstating, I think the system's broken at all levels. And so I'm not seeing now that you have a world of in-house legal departments, major organizations who are the haves, and the have-nots are the consumers. I think we need to rethink right across. There's different uses of technology, some are essentially organizational technologies where you're getting big businesses investing and law firms investing in systems. But the second half is about the role of the state on the one hand and the role of we call it the commons on the other. So the role of the state, it seems to me, is to rethink in relation, for example, to legislating, in relation to court service and so forth, is to rethink the way it operates, not to streamline it through technology, but to use technology, as we did say with online courts, to say, actually, we don't need the idea of investing in technology in courts isn't about making our court system streamlined. It's about saying we can resolve disputes without physically congregating. So the mindset of the state has to be, we legislate, we provide authoritative methods of dispute resolution. Hopefully, we offer guidance on legal subject. And our mindset has to be, we bring fundamental change. For me, the more interesting thing, though, is whether you call it the commons. But what we're seeing is this build-up in a variety of ways. And the simplest examples one can give are of Wikipedia and open source software. We actually have communities of users. We're seeing it in medicine, we're seeing it in architecture, we're seeing it in tax, and I think we'll see it in law as well, where for consumer law, people help one another. And it's a great community venture. I think the state will probably need to put in place the platforms to support that and maybe even moderators to help through. So what I'm saying is for the haves, there's some expensive technological solutions that they'll need to bring to bear because they have problems of inaccess. And for the traditional have-nots, the consumers, the people who are who have been disadvantaged traditionally, it seems to me the state has a burden to rethink its fundamental role in using technology to support a justice system. And also this fantastic, I think, possibility of building up these communities of professional experience. On the question of imbalance, what was very much in our mind with online courts was, and this is where one of the judges was misinterpreted, we're not saying we want to exclude lawyers, but we want people who are not, if a person's got a dispute with a big insurance company, for example, we do not think it appropriate that because they are commercially disadvantaged, they have less resource, that they should be legally disadvantaged. And part of the introduction of the online resolution systems and the online court, and again, it's the state taking a different view, is somehow to redress that imbalance. I'm not sure if it's a full answer to your question, but when I was writing this talk and when I was writing the second version of my book, I was increasingly seeing that the same issues on a different scale apply to citizens and apply to big businesses. We need to rethink and upgrade the justice system generally. Okay, so there's a question there and a question there. We'd take the gentleman in the back and then the lady in the middle. Yes?
Thank you very much for the very interesting talk. I'm a big fan of your research.
Thank you. I like this chap already.
Yeah. It seems like the technology and AI and big data and everything is just taking like a lot of jobs. Like from a big law perspective, I've seen like Baker McKenzie in the US, they have just established a so-called innovation committee, like a global one, to sort of incorporate technology in the day-to-day legal works, to review contract, to read documents and everything. So it seems like there will be a huge loss of job for at least first year and even second year associate, because of the very routine job that can be lost to automatic and AI and robots. And it seems like there is a statistic saying that until now to 2020, the 5% of the legal job will be lost to automatic in the US because of all the technology. And so what is your recommendation for practitioner, young practitioner? How can we equip ourselves to cope with the very foreseeable future?
It's interesting.
Or our last resort will be like Elon Musk said like a couple of days ago, like humans need to be merged with technology, otherwise human will become irrelevant.
Well, there is a view, and it's not a view I'm going to discuss today, that it's probably the 30s and the 40s, and people call it the singularity. There's a whole bundle of different things when very advanced technologies will play a fundamental and dominant role in society, and indeed will become, as human beings, digitally enhanced and all the rest of it. Let me put that to one side just now. What I'm talking about is the 20s. I think your language is interesting because you said taking our jobs. You know, I would argue you don't have jobs yet. And what I was trying to put up and saying is actually there's a whole bundle of new jobs for you in the 20s. And I think the most exciting thing I've ever done still professionally was developing that latent damage system. Intellectually, and in terms of creativity, it was just fantastic. That's the job of the legal knowledge engineer. In a way, you could all train for that. So it may well, the jobs that you call ours, and a little bit of a, if you'll forgive me, sense of entitlement, which I think none of us can have any longer. We can't feel entitled to jobs. These jobs are going to be in shorter supply. The economics of this are very, very simple. That the first and second year work of so many people in law firms is document review, either in litigation or in due diligence work. That's a fact. Historically, clients haven't minded to pay for your training. Now it's part of the more or less challenge. They're saying, look, if we don't send this stuff to India, we can certainly, or to the Philippines, we can now use technologies that undertake due diligence and document review exercises to higher quality often than junior lawyers. I cannot imagine this isn't going to give rise, not over the next 2 or 3 years, but over the next 4 or 5, 6, 7 years, to fewer people being admitted to law firms to do that kind of work. But at the same time, what we're seeing is these new jobs, these new tasks coming through. we think the phrase job is rather unhelpful. It's more, what are the tasks you do under the heading of job? So if you think of a nurse in the 1980s, it was all about bedpans and bedside manner. Today, a nurse, same label, will often be writing out prescriptions, undertaking minor operations. Call them nurse, the tasks are very different. So by 10 years from now, you'll still be called a lawyer, but you'll actually be doing entirely different tasks. And it seems to me that, and it's not just in law, it's right across the professions, we're going to go through a period of great change over the next 10 years, where the really innovative and exciting firms will be looking for young people not to review documents, but actually to undertake project management, to be involved in systems design, to be thinking about introducing online platforms for courts and dispute resolution. A few of my clients are like that. They cannot get enough people, say, involved in legal process analysis. The more conventional firms will struggle because their pyramid is being, their profitability pyramid is actually being closed at the bottom. They will, I think, take on fewer junior lawyers to do the more traditional work. And to that extent, you can see there'll be less of a demand for the kind of work that many of you thought you were going to be undertaking. And that's my point. That's my reason for being here today. The future of law, it's not John Grisham. It's not Rumpel of the Bailey. It's not Suits. It's not The Good Wife. I love them all, but that's not 21st century lawyering. And you're probably just at the, in a way, you might be able to pull the ladder up after yourselves. Your generation, there'll probably be an intake over the next 2 or 3 years, and the work will still be fairly traditional. And David will say, I suspect, and I agree with him, that although we talk about things like document review and litigation and due diligence work, still they're relatively rarely used, even in the firms that are using them a lot. So it'll be 3, 4, 5 years before they become more mainstream. So you might be able to slip in there at the end. But my message to people who are coming through at the beginning is this has never been a more exciting time. You have the privilege, not just of taking the baton from the person ahead of you a couple of years and doing what they did, but actually being involved reshaping the justice system. Wow. I wish I was your age again. There was one more question. I'm conscious of time.
Thank you very much for a fascinating talk. Thank you.
And I'll give a quick answer. Right, rapid fire stuff.
So thank you for a fascinating talk, all the more fascinating because you said you have a background in jurisprudence and legal philosophy.
Yeah.
And I was wondering if the underlying idea was that perhaps H. L. Hart might be having a last laugh. And I was wondering if the end of lawyers might mean, what it might mean for the future of jurisprudence and legal philosophy.
Sorry, I heard you until the end of lawyers. What was that just at the end?
What that might mean for the future of legal philosophy and jurisprudence in general.
Oh, okay. Okay, I'll answer that in a second.
Yeah, so my question was about online courts. I was working at the Court of Appeal when your report came out.
Yeah.
And one of the things that really concerned me when it did was that we were seeing a lot of litigants in person mostly who had got to the point where they'd had a number of decisions made on their case, almost always on the papers, the right legal decision. But what they felt was that they hadn't been heard, and all they wanted was for somebody to listen to them. And the kind of the decisions on the papers that we're seeing more and more in England, and the kind of online proposals, the eBay type dispute resolution proposals, isn't going to give those people the main thing that they want, which is for somebody to listen to them. And that's my biggest concern about it.
It seems to me legal philosophy, everything that I discuss has got great implications. I wish that there was a whole school of jurisprudence looking at these issues I'm talking about from an analytical point of view. So it seems to me there's a whole new set of things legal philosophy can look at. I agree generally with your point. I mean, Hazel Genn's done fantastic research in England about why people actually go to courts, and often it's for an apology and rather than a legal remedy. What I've been tremendously influenced by is the work that the tribunals have been doing in this. The response mainly in the courts has been to cut and paste the adversarial system into an online environment and think that'll do okay, but it won't for the reasons I think you're mentioning, that actually people want to feel they've been heard and there's something more interactive. The tribunal judges have got this idea of an online ongoing dialogue where there's far more interaction, there's far more communication, there's far greater opportunity to express that there's an understanding of how they feel. So it goes back to my whole point that we shouldn't think that the purpose of technology is to simply have a an online version of something that already goes on. We have to use our imagination to ensure that your concerns are met. And remember, it's increasingly more and more litigants in person will belong to the internet generation. Being listened to will not involve physically being listened to. It'll be involved with an online dialogue. So I'm designing, in my own mind, these systems for the 20s. I'm not designing them for 2017. But it's an important point that you raise. Thank you very much.
We've met the future. It's here. The future will stay for a minute.
Sure.